When someone you love passes away, the bills don't stop. The mortgage is still due. The lights still need to stay on. And almost every family I work with asks me the very same question. Can I just keep paying everything out of mom's bank account? It feels like the obvious thing to do. But here in California, the answer is usually more complicated than people expect, and getting it wrong can cost you. I'm Shanty Soerjono with eXp Realty. I specialize in probate and trust real estate here in California, and I walk families through this every single week. Before we go further, one important thing. I'm a real estate specialist. I'm not an attorney, I'm not a CPA, and I'm not a financial advisor. Everything in this video is general information to help you get your footing. It is not legal, tax, or financial advice for your specific situation. For that, please work with a licensed probate attorney and a tax professional. So, can you pay bills from the deceased person's bank account? It really comes down to three things: who owns the account, how it is titled, and whether anyone has the legal authority to act for the estate yet. Let's start with the hard truth. If the account is in your loved one's name alone, then before probate is opened, the answer is usually no. Family members, even a surviving spouse, even the children, do not automatically get the right to use that account. And once the bank is notified of the death, it will normally freeze a solo account until someone has legal authority to access it. At that point, the bank will generally release the money to only one of four people: a court-appointed personal representative, that's the executor or administrator, someone using a valid California small estate affidavit, if the estate qualifies, the surviving owner of a joint account, or the named payable on death or transfer on death beneficiary. Now, joint accounts work very differently. If the account is a joint account with right of survivorship, the way a lot of married couples hold their checking, the surviving owner usually becomes the sole owner the moment the other owner passes away. That surviving spouse can generally keep writing checks, keep making withdrawals, and keep paying the household expenses without opening probate at all. Those funds pass outside of probate because ownership transfers automatically to the surviving joint owner. The surviving spouse just needs to notify the bank and provide a certified copy of the death certificate. One caution though, not every joint account is set up the same way. The bank will follow the account agreement, and if ownership isn't clear, they may temporarily restrict the account until they've reviewed the paperwork. And here is where a lot of people get tripped up. Even if you are the surviving husband or wife, you do not automatically have the right to an account that is titled in your spouse's name alone. California is a community property state, but that by itself does not give a surviving spouse access to an individually titled bank account. Banks follow the legal ownership shown on the account, and they generally require proper legal authority before they will release any funds. So should the family just cover all the bills out of their own pockets in the meantime? Here, please be careful. In most situations, you should not, at least not until you understand the legal and financial consequences. The reason is simple. The estate, not the children, not the beneficiaries, is generally responsible for the deceased person's debts unless someone co-signed or is otherwise legally liable. California probate law sets the order in which those debts get paid. And if you pay the wrong bill too early, you can create real problems for the estate and even expose the personal representative to personal liability. So what changes once someone actually has authority? Once the probate court appoints a personal representative and issues letters, either letters testamentary or letters of administration, that person finally has the legal authority to act. They can collect the estate's assets, access estate funds, open an estate bank account when it's appropriate, pay valid estate expenses, pay approved creditor claims, and keep detailed records of every payment coming in and going out. And they carry a fiduciary duty, a legal obligation to act in the best interests of the estate and its beneficiaries. Which brings us to the question I get asked the most. Which bills should actually keep being paid? Generally, the expenses that protect the value of the estate's assets, and especially the real estate. That means the mortgage payments, the property taxes, the homeowner's insurance, the HOA dues, the necessary utility bills, and any emergency repairs needed to preserve the property. Let those slip, and you can quietly reduce the estate's value, trigger a lapse in insurance coverage, or, in the worst case, lose the home to foreclosure. This is the part I care about the most, because the house is usually the single most valuable asset in the entire estate. So, which bills can usually wait? Many unsecured debts, credit card balances, personal loans, medical bills, are typically handled through the probate process rather than paid immediately. Creditors generally have to submit a claim against the estate, and the personal representative decides whether each claim is valid before paying it, in the order California probate law requires. And don't overlook the quiet ones, the automatic payments. A lot of subscriptions and recurring charges just keep pulling money after someone passes. So the personal representative should review the recent bank and credit card statements, identify the automatic withdrawals, cancel the subscriptions and memberships that aren't needed, and keep only the payments that actually protect the estate's assets. Let me make all of this concrete with two quick examples. First example, John and Mary have a joint checking account, and John passes away. Mary is the surviving joint owner, so she can generally keep using that account to pay the bills, and it usually does not go through probate at all. Second example, John has a checking account in his name only, with $75,000 in it. After John passes, the bank freezes the account as soon as it's notified of his death. And even though Mary is his wife, she generally cannot access that money until she has legal authority through probate or another legal procedure that allows the bank to release the funds. Same couple, completely different outcome, and the only thing that changed was how the account was titled. So here is what I want you to take away. Joint accounts generally pass directly to the surviving owner and usually skip probate. Individual accounts are generally frozen after death until someone has legal authority. Being married does not automatically give you access to an account held in your spouse's name alone. The personal representative should pay only valid estate expenses and creditor claims using estate funds. Keep the essentials going: the mortgage, property taxes, insurance, and HOA dues to protect the estate's assets. And beneficiaries should not receive any distributions until the debts, the taxes, and the estate expenses have all been properly addressed. One more time, because it truly matters, this video is general information only. It is not legal, tax, or financial advice, and I am not an attorney or a CPA. Please speak with licensed professionals about your specific situation. And if you're a surviving spouse, an heir, or an executor here in California and there's a house involved in the estate, I offer a free, no-pressure consultation to help you understand exactly where you stand and what happens next. I'm Shanty Soerjono with eXp Realty, and you do not have to figure this out alone.